Further hearing in the appeal, Naresh Boodram against Attorney General of Trinidad and Tobago.
Mr. Sipersad, good morning.
Morning, my lords.
Further hearing in the appeal, Naresh Boodram against Attorney General of Trinidad and Tobago.
Mr. Sipersad, good morning.
Sorry, good morning, my lords. May I begin, my lord?
Yes, please. Thank you. No, we have a problem, I think.
Mr. Simpson, good morning. Good morning,
Right, we'll rise for a moment while this is sorted out. We do apologise. Mr. Sipersad.
Thank you very much, my lord. My lord, before I pick up or seek to pick up from where we left off yesterday, there are two very brief points I wish to make. The first is in relation to the local authority of Thomas and Paul, which was repeatedly, to which I repeatedly referred the board yesterday, which was it's at electronic bundle 877. Just briefly, my lord, indicate that authority has never been questioned or doubted in any of the local decisions. And secondly, and an interesting fact is that it was cited to the Judicial Committee in Pratt and Morgan in argument, and that appears at electronic bundle 936 in the citations, and it also appears to have influenced the board's decision on the width of the language and the powers thereunder in relation to Section 25 of the Jamaican Constitution. Second point, my lord, is overnight. We've had a brief look at the judgment of the Court of Appeal, and in particular, paragraph 34, which is at the electronic bundle, page 77. We have, the board should have before your lordships, a few new authorities, and I apologize for the lateness of those authorities. The decision referred to by the Chief Justice of Clifford Beckles is one of those decisions. Put that for the board's consideration for the sake of completeness.
Is this Hunt?
Sorry, my lord?
Is this additional authority Hunt? Yeah.
No, my lord, that the additional authority Hunt was provided by the appellant yesterday. If I can just identify what those additional authorities are, it's Clifford Beckles and the state, David Abraham and the state, Lester Pittman and the state, all of which are decisions of the local Court of Appeal. And there is one decision to which we shall be referring later, which is a decision of the board in Skeet and the state.
Do you have these, Ben?
Yes, I did, but I haven't just trying to pull them up now. And they came in by email this morning. And,
bear with us if you would, Mr. Sipersad.
Yes, ma'am.
I have to say I didn't receive that email, I don't think.
No, I didn't either. I mean, I did receive an email from the registry this morning. But that has only two authorities, Hunt Khan and the state, and Section 69A of the Interpretation Act.
I haven't got anything more than that.
I don't think any of us have received anything other than that.
Well, my lord, we'll have that remedied shortly. I do not propose to take my lords directly to the cases, just to indicate certain paragraphs.
Right.
And a position which is found explained in those cases.
Thank you.
If I may just deal with that quickly. It's the decision of David Abraham and the state and Lester Pittman, and it's in relation to David Abraham and the state, paragraph 5 and paragraph 14. In relation to Lester Pittman and the state, it is paragraph 71 and 72. And the short point is, in both those decisions, the Court of Appeal applied Pratt and Morgan in relation to sentence on a criminal appeal, which we now understand to be the wrong approach. But what is instructive is that in those two decisions, the Court of Appeal indicated that in relation to applying the general guidance of Pratt and Morgan, which we went through yesterday, the Court of Appeal had a discretion to depart from that general guidance where special circumstances existed. It is not at all as simple as merely just applying Pratt and Morgan, the general guidance as to life sentence, even if it was the case that there was general guidance in relation to the life sentence.
So your point is that although it's now established that it shouldn't have been treated as a criminal appeal because it was a Pratt and Morgan case, nevertheless there was a discretion in the court when it did consider the matter to grant a sentence other than life imprisonment. Thank you.
Yes, ma'am. Yes, ma'am. Yes, it's very clear on that they felt free. The Court of Appeal felt free to depart from that general guidance as to a mandatory life sentence where special circumstances existed. My lord, returning to where we left off yesterday, we were on. I can just reference it by virtue of the appellant's arguments. We were on the appellant's second reason as to why the Court of Appeal was wrong to make the order it did. And that is contained at electronic bundle, which is, I'm now referring to the appellant's submissions, electronic bundle 423 onwards. By those submissions, two criticisms are made in relation to the decision of the Court of Appeal. One, that the Court of Appeal appears to have overlooked the fact that Matthews overruled Rudall. And to take the argument to its logical conclusion, the Court of Appeal applied Rudall over Matthew. The appellant says that the Court of Appeal was thereby attempting to remedy the mandatory nature of the death penalty. We say that this criticism is misplaced for the simple reason, on a fair reading of the decision of the Court of Appeal, both Rudall and Matthew were dealt with as part of the jurisprudential landscape which applied to the mandatory death penalty. And therefore, it is unfair to say that the Court of Appeal overlooked the effect of these cases. The appellant further makes reference to paragraph 20 of the Court of Appeal's decision, which is at electronic bundle, page 72. But and our response is very clearly that the appellant has unfortunately taken this paragraph out of context. If I can read it very, very briefly, at least the first part of that. Lordship, Chief Justice, says the mandatory death sentence in Trinidad and Tobago. Sorry, mandatory death sentence is the law in Trinidad and Tobago, and it is within the realm of Parliament to change it. However, the courts are charged with upholding the Constitution, which is the supreme law of the land. We must resolve that tension. My Lord, what, in our respectful submission, what the Court of Appeal was there doing was it expressing the task which was before the Court of Appeal. There was a mandatory death sentence, or rather, there is a mandatory death sentence. That mandatory death sentence is currently saved by the operation of Section 6. It remains valid and subsisting as a law. However, having regard to the manner in which the executive has approached these executions, i.e., the inordinate delay of over 5 years, where an offender convicted of murder comes under Section 14 to the court, it is for the court to resolve the tension between a mandatory death sentence, which is still on the books, and so as to provide appropriate relief under Section 14. And that is the tension to which His Lordship was referring to there. And further submit, my lords, that that tension was correctly resolved by the order of the Court of Appeal. One further criticism is made in relation to paragraph 33. Sorry, no, not 33. In relation to the reference to Rudal, where sorry, that is also at paragraph 20, I apologize. That is towards the end of paragraph 20. But there, the Court of Appeal is referring to the philosophy in relation to a mandatory death sentence being arbitrary and lacking proportionality. There is nothing, and His Lordship, the Chief Justice, was very correct in saying that there was nothing in Matthew which undermined that underpinning philosophy. That philosophy in relation to any mandatory sentence, in fact, is applied in the Court of Appeal's judgment in relation to a mandatory life sentence, which is precisely what the appellant urges upon the court. And therefore, the appellant's argument, which appears to say that the Court of Appeal has a preferred Rudal over Matthew, that argument is based on taking that dicta of the Court of Appeal out of context. And so, the respondent submits that those criticisms made of the Court of Appeal are not correct and they are entirely misplaced. Turning to the appellant's submissions at paragraph 34 of the appellant's case, which begins at electronic bundle 425 and continues over leaf. This is in relation to the dicta at paragraph 35 of Lendor at electronic bundle 773, letter F to G. In the main, the respondent relies on its written case in response, which is at our paragraphs 3.29 and 3.30, which is at electronic bundle 445 to 446. To that, just wish to add one point. It is not possible to distinguish the dicta of Lord Hughes and Lendor from the decision in Pratt. I do not propose to read once again, because we have dealt with this dicta before in these proceedings, but just to identify it for the board's consideration. The dicta at Pratt and Morgan, at electronic bundle 966, letter A, and the dicta of Lord Hughes in paragraph 35 at electronic bundle 773. You say on a fair reading and comparison of that dicta, the dicta cannot be distinguished because essentially lender follows the conclusion in Pratt and Morgan, so that in Pratt and Morgan, where Lord Griffiths is speaking of, and I quote, substituting for the sentence of death such order as it considers appropriate, his lordship is clearly referring to precisely the exact thing as Lord Hughes, where Lord Hughes puts it as an appropriate substituted sentence. And therefore we say that the attempt to distinguish those two cases is artificial. My lords, the third reason advanced by the appellant is that the only appropriate sentence is life imprisonment. And this will, our response to this will take us to a detailed consideration of life sentence in Trinidad and Tobago. But before we come to those submissions rather, just to point out that this issue as framed by the appellant is precisely the very issue which is being remitted to the High Court by the order of the Court of Appeal. What is an appropriate sentence in these circumstances? As I understand the appellant's submissions, and I hope I do understand them as intended by the appellant, these submissions are really based on the proposition that, firstly, a life sentence is the next most severe sentence, and as a result of that, it necessarily follows that it is the only sentence that can be substituted for the sentence of death. In response to that, my lord, we say as follows. While it is that the sentence of life imprisonment does appear, it definitely does sound as though it is the next most severe sentence available to a sentencing court. The observations to which I will refer the board in a moment do not bear this out. And if I can refer the board to the decision of Madam Justice Sue Hon, as she then was sitting in the criminal court as a senior criminal judge. And that decision is the decision of Citation and Pancho and the State, which is found at electronic bundle 1065. Just to put this decision in context, this was a sentencing hearing for juveniles convicted of murder. The sentencing hearing was actually taking place 30 years after the initial conviction. And this is the same Citation and Pancho duo which found its way to the Judicial Committee in relation to civil proceedings brought under the Constitution, which is before the board in our supplemental electronic bundle, and to which is probably the last case I will refer the board to in relation to point 4, issue 4 raised by the appellant. The sentence having been modified from one of president's or state's pleasure to one of court's pleasure, it was referred, the criminal matter was reopened and sentencing was referred to the criminal courts. The argument which was advanced on behalf of those convicted persons was that the court was bound to impose a sentence less severe than a life sentence, and the life sentence at the time was understood to be in practice 15 years. And at that point, I refer the board to electronic bundle, page 1074, beginning with the second paragraph. And if I may read that second paragraph, counsel for the applicants submitted that a term of life imprisonment in 1986, when these applicants were convicted and sentenced, comprised no more than 15 years. It was confirmed by the Deputy Commissioner of Prisons that persons who were given life sentences were reviewed every 4 years and were discharged between 13 and 15 years. He also went on to say that there had been no such discharges recently. In this connection, see page 15 of Chuckatin on the 6th of December 2005. I must convey respondents' apologies because we do not have that transcript before the board. The unfortunate reason for that note is that our library here is closed due to the COVID restrictions. But what actually occurred in that case was that on the hearing of a criminal appeal as to sentence for a juvenile convicted of murder, the Court of Appeal, in attempting to lay down guidelines as to how that sentence ought to be executed in the absence of any statutory framework, summoned to court the Commissioner of Prisons to indicate what was the position regarding the practice of the life sentence currently, and that was in 2005. So putting it in its context, if I can direct the board to the next paragraph, where Her Ladyship says, whilst a term of life imprisonment in the past did not go beyond 15 years, this did not mean that where appropriate, the court wishing to impose penalties in excess of a term of 15 years did not have the power to impose such specific terms if the circumstances so required. Lord, we commend this particular passage as a recognition of the situation where, and this is in law and in practice, where a court is making it clear that they were entitled to pass sentences which in practice would be more severe than a life sentence. And there are two cases which I referred to thereafter. So, my Lord, this is, sorry, and I should indicate Madam Justice Sue Hon. I believe Madam Justice Sue Hon, yes, Madam Justice Sue Hon was part of the quorum that dealt with this very appeal before the Court of Appeal in these proceedings. And that is referred to by the Chief Justice in paragraph 29 of the Court of Appeal's decision at electronic bundle page 76. So that it is not at all clear that the only sentence, or rather the most severe sentence available to a sentencing authority is a life sentence. And again, I'm speaking of in practical terms. And in that case of Citation and Pancho, Her Ladyship actually imposed a minimum term of 30 years. So clearly, if it was the case that a life sentence was 15 years in practice, Her Ladyship was imposing a sentence considerably more severe than a life sentence in practice. So it definitely sounds as though the life sentence is the next most severe. But the point being made is that it is not always so. And experience in terms of the sentence, in operation of the sentence in practice, shows that it may not be so at all. And I refer your lordships to the dicta of the Chief Justice, to which I shall return. I will just indicate what it, that part. The Chief Justice was definitely correct that a court must be able to articulate the punishment it intends to impose. And in these circumstances, it would be very difficult for a court to articulate what is meant or what is even intended by the imposition of a life sentence by that court. And in dealing with the life sentence and the imposition of a life sentence before a court, it is no regard should be paid to executive action under Section 87, i.e. the mercy provisions, for the simple reason that an offender has no right to the application of those provisions to his sentence. He has a right, pursuant to Lewis and the Attorney General, to procedural fairness and so on. But there is no right to mercy, and that part of the Freitas and Benny still stands. The appellant's submissions actually beg the question as to how the court is to weigh the gravity of the offense. And on a proper consideration of that issue, respondent says that the weight of the gravity of the offense must involve a consideration of the circumstances of the offense and the offender. This obviously accords with general common law principles relating to sentences and also the fundamental rights. For any sentence imposed must be shown to be rational. But it is this very consideration which the appellant's submissions seek to deny a court. The appellant further submits that regard is to be had to Section 4 again of the Offences Against the Person Act, which does, by its terms, treat all murders as equally grave. Therefore, as I understand the submission, a court should also be treating all murders as equally grave and imposing a mandatory life sentence without further consideration. But, my lords, we did touch upon this yesterday in our submissions, but the respondent makes it clear that Section 4 and the operation of Section 4 of the Offences Against the Person Act has no bearing on what an appropriate sentence should be in the exercise of the court's discretion under Section 14(2) of the Constitution. And further, that submission actually conflates the two jurisdictions, one being the jurisdiction of the criminal court, hearing a trial and indictment, and having the only option, the only available sentence, rather, is a mandatory sentence. That is conflated with the very wide discretionary powers under Section 14(2). And therefore, it is not correct to say that Section 4 of the Offences Against the Person Act has any bearing on the issue now before your lordships. Finally, on this point, before we come to the life sentence, drawn to its logical conclusion, the appellant's argument, and it is not, in all fairness, it is not expressed in these terms. The appellant's argument is really that, having regard to the mandatory death penalty, all persons who can no longer be executed must also be left to die in prison. It is another death sentence which is being urged upon the court, and we will come to that. I will flesh that out in dealing with the operation of the life sentence. And this is clearly shown by the reference to in the appellant submissions that all murderers must die. And to this point, we say firstly, this proposition doesn't follow. And it certainly does not accord with the purpose of the jurisdiction under Section 14, which is to vindicate the right of the respondent. The next point, my lords, is raised at paragraph 39 of the appellant submissions, which is found at electronic bundle 427. And the nub of this submission is that the Court of Appeal proceeded on an erroneous basis that the life sentence in Trinidad and Tobago is irreducible. Firstly, my lords, His Lordship the Chief Justice did not so proceed. The word irreducible is not to be found in the decision of the Court of Appeal. Moreover, my lord, I was counsel in the Court of Appeal, and I can indicate that the reducibility or otherwise of the life sentence was never a feature of the argument. The issue in relation to the life sentence was raised in a very different manner, and it was raised in this form. What was argued by the appellant in the Court of Appeal, now the respondent before your Lordship's board, was that on a closer examination of the life sentence in practice, there were serious concerns, and those concerns militated against the proposition that a life sentence is an appropriate sentence to be applied in all cases of commutation. And just for the attention of your Lordships, I can just note that those submissions are before the board in the record and are to be found at electronic bundle 47 onwards. And there and those are the written submissions of the appellant before the Court of Appeal. So no issue was ever raised as to irreducibility of the life sentence. And obviously, therefore, the board does not have the benefits of any of the views, or rather the possible views of the Court of Appeal on that issue. And in fact, my lord, on a fair reading of His Lordship's judgment in the Court of Appeal, it is very clear that the Court of Appeal examined the life sentence and did make reference in terms of the operation of the life sentence, which shows that it was actually considered as reducible. But as I've just indicated, that was not the issue before the Court of Appeal. And in terms of the appropriateness of the sentence, mandatory sentence of life, if I may draw the board's attention to just two paragraphs, which I don't propose to read. Terminals with, I've just had a technical difficulty here.
Do take a moment to sort that, Mr. Seepersand.
Well, I'm just remedying a technical difficulty. I'll be back shortly.
Yes, of course.
Is this plugged in? No. Right. I apologize, my lord.
Not at all.
Paragraph 24 at electronic bundle 74 and paragraph 44 at electronic bundle 83. And in particular, paragraph 44, His Lordship indicates, the numerous and varied cases that we have examined provide a clear indication that simply resorting to the imposition of life imprisonment brings neither clarity, proportionality, nor certainty to the exercise of fashioning an appropriate remedy under Section 14 of the Constitution. And they're encapsulated in very broad terms is the conclusion in relation to the issue of the appropriateness of a mandatory life sentence upon commutation. The dicta referred to by the appellant at paragraph 40 of its submissions is taken out of context by the appellant, respectfully. In those paragraphs from 44 onwards, beginning with 45, the appellant draws the board's attention to dicta at paragraph 46 to 49 and 50. But that dicta was in relation to a comparative discussion of the situation which obtained in other common law jurisdictions regarding the life sentence. And that is very clear because that part of the judgment is actually headed the international standard. And at paragraph 50, the observation made there about there being no legislation within this jurisdiction providing for a review mechanism is part of that comparative discussion because it's preceded by paragraph 49, which is dealing with the situation in, I think it's, and in Antigua and Barbuda that does have legislative provisions for providing an available scheme for early release for offenders serving life imprisonment. So, in other words, in wrapping up this point, we say that there is nothing in the judgment and nothing has been put forward by the appellant to suggest that the reducibility or irreducibility of the life sentence in any way influenced the court's decision to make the order that it did. These were merely observations of the Court of Appeal. My Lord, at this juncture, the arguments bring us to what is probably one of the most important points, and it was raised by your lordships at the commencement of the appeal yesterday, which is what is the situation regarding the practice of the life sentence in Trinidad and Tobago. So, my lords, in assessing the life sentence, we wish to start with the unexceptional proposition that each jurisdiction is likely to have some form of imprisonment for life, and each jurisdiction is likely to have its own rules and regulations, be they by way of common law or be they by way of statutes, that pertain to the proper execution of that sentence in each jurisdiction. And of course, it goes without saying that those rules may differ from jurisdiction to jurisdiction. But putting the operation of the life sentence in context in Trinidad and Tobago, we just wish to make the following brief points. Firstly, there is no statutory framework for the execution of the life sentence in Trinidad and Tobago. Secondly, there are no license provisions for release in this jurisdiction. And for completeness, just wish to say the only license provisions which are on the books in Trinidad and Tobago pertain to juveniles under sentence of court's pleasure, which clearly will not apply to circumstances such as those before the board. Third point is that there is no parole board. There has been discussion many years, but we still do not have a parole board. And moving on, and in furtherance to that submission, we have nothing in the form of an independent or impartial tribunal which deals with the determination and execution of sentence of life imprisonment. The fourth point is that there is no stated policy by the executive in relation to life sentences. Further, there is nothing to show the form of consideration afforded to reviews under Prison Rule 281 and the reports prepared thereunder. And I just pause to note, my lords, that those prison rules are, I think it's 1948. They're made under the 1834 West Indies Prison Act, but I think those prison rules were enacted in 1948, I think. But I'll have it checked, and if I'm wrong, I will inform the board. But the point being, they're somewhat archaic. Matters have somewhat moved on from 1948, clearly. And the last point in this context, which is an important point, is that at present, we know nothing of the functioning of the Advisory Committee on the Power of Pardon under Section 89 of the Constitution. And in this respect, my lords, I can draw reference to the Lendor case, where the order of the Court of Appeal was 6 years ago, which made it very clear that all persons commuted under Pratt and Morgan had to be returned to the Mercy Committee, the Advisory Committee on the Power of Pardon, to have a reconsideration. This order was confirmed by your Lordship's board 4 years ago in Lendor, and I can speak from the perspective of being counsel for a number of those persons, that to date, no one has been subject to a meeting of the Mercy Committee, and no one has been invited to make representations thereto. So that dealing with the context in which these submissions are made, we turn directly to, as a matter of law and in practice, what the life sentence means. Firstly, life sentence, as a matter of law, and I say this is trite law, an order for life imprisonment authorizes the detention of the offender for the rest of his natural life. It is stated somewhere that the life sentence ends. I can't remember where, but the life sentence ends when the last breath leaves the body. And that is clearly the position in law. But as the decision of the Court of Appeal shows, the life sentence in practice is a very different proposition altogether. For it is shown, and I will take the board to the relevant authorities, but it is clearly shown in the judgment of the Court of Appeal, and I've just asked the board to note paragraph 30 of the Court of Appeal's decision, which is that electronic bundle 76. The last part of that paragraph, and I'll be returning to that, but I just asked the board to note that for present purposes, that the determination of the life sentence in this jurisdiction is left to the executive under the application of the mercy provisions, as it was done many years ago in England. We are still under that regime, is the point that I'm making. Section 69A of the Interpretation Act, which was the point at which we left the matter yesterday, is merely a recommendation by the trial judge, by declaring the trial judge's views as to the period before which, not before which, sorry, that a person should be considered for release. So, for example, in the Pittman Authority I referred your lordships to earlier, the Chief Justice imposed life imprisonment and declared not to be released before 40 years. Now, my lords, that the case of Marcel Skeet and the state, which was or ought to have been before your lordships this morning from the respondent, is a decision of the board which makes it clear that the declaration made under section 69A is a freestanding declaration and does not form part of the sentence.
Is a trial judge, forgive me, Mr. Siperset, is a trial judge required in each case to make such a recommendation, or it's optional?
It is, my lord, and the section at line 4 makes it very clear. May, notwithstanding anything contained in any other law, declare. So it's entirely within the purview of the trial judge, discretion of the trial judge. It is unfortunately misread often, and even in this jurisdiction, it is often misread as being as part of the order of the court, when it clearly is not. And the reason for this section is very clear. It's because the life sentence is not merely administered by the executive on the normal principles, but it is actually an integral part of that sentence is that the life sentence is to be determined by the executive. And that is the accepted practice in this jurisdiction. Unlike...
Mr. Siperset, just going back to section 69A,
yes,
it says it applies where punishment of imprisonment for life is provided for a criminal offence by any written law.
Yes, my lord.
Does that cover our case? Is there a written law?
No, my lord, it doesn't. We're strictly on common law. But I do see the point, but I'm really just laying out the operation of the life sentence in the jurisdiction in an attempt to assist the board with dealing with the issue of whether there should be a mandatory life sentence.
So the provision wouldn't apply to
no, my lord, it wouldn't.
A case such as
but it has been applied by the Court of Appeal, notwithstanding the terms of the section, because in those authorities which have been passed to the board this morning from the respondent's side, those are all cases of murder. And therefore, no, there is no written law which provides for punishment by way of imprisonment for life for the offense of murder. Returning to the issue of the termination of the life sentence by the executive, it's very important to note that this process differs it differs from any other sentence of imprisonment. And I say so because any other sentence of imprisonment can be determined by the mercy provisions by the grant of a pardon. Any sentence. But the difference is, and it's recorded in the cases, that in this jurisdiction, it is intended as an integral part of the sentence for the executive to make that determination. And it is because of the, and it's clearly seen by the number of the numerous pronouncements by the local courts as to what a sentence of life imprisonment means in practice. And these are general. I'm sorry, we're back. These are, I was saying that these are generalized statements applying across the board to life imprisonment and life sentence to life imprisonment. These are and it is on this basis that the courts have repeatedly held, firstly, Thomas and Paul, life sentence in practice means so many and so many years. In Edwin Farfan and the State, which I believe is referred to by His Lordship in the Court of Appeal, 12 to 15 years. As I recently, this morning read to the board the case of Citation and Pancho, in excess of 20 years. So that generalized statement can only be based on the sentence of life imprisonment being brought to an end. And it is an unexceptional proposition that to say the only way in which a sentence can be determined is either by an appellate court or by executive action under the mercy provisions. And clearly, the actions of the appellate court are not applicable to the point here. So that it is clear, and this is what is meant at paragraph 30, which I will now go to, paragraph 30 of the judgment of the Court of Appeal at electronic bundle 76, where His Lordship, this is halfway down into the paragraph, His Lordship is referring to the submissions of the respondent, now the appellant, before the Court of Appeal, as to there being only one sentence, and it's there, court must substitute the next most severe sentence that would mirror the gravity of the offense, i.e. life imprisonment. However, that argument is only tenable if all murders are regarded as equally grave. And this is the important part. It requires the court to approach commutation as a rigid and inflexible exercise which cannot take into account the peculiarities of the individual applicant's circumstances. And crucially, my lords, and shifts responsibility to the advisory committee under section 87 of the Constitution. My lords, I commend that last part of the paragraph to your lordships as a clear indication that the operation of life imprisonment, rather the sentence of life imprisonment in Trinidad and Tobago, does shift responsibility to the advisory committee or the executive to determine that life sentence. Now, just to make this clear, my lord, the respondent by these proceedings is not in any way challenging the constitutionality of the life sentence. That has not been raised in the proceedings below and ought not to be raised before the board. And in fact, it is not part of our arguments at all. Our arguments are based on there are concerns as to the operation of that sentence, which militate it being found without more as the only alternative sentence or an appropriate sentence in all cases. Now, probably before 1990. So I'm getting, sorry, my lords, I'm getting some messages on my screen. I don't know if my Lord Hamblin is also getting it, that there's a delay in the picture. Is that correct? Is the board losing me?
There have been some momentary breaks. But we've been able to follow. We've been able to follow your argument so far.
Right. Yes, my lord, I can indicate that, and I can say probably prior to the 90s, persons were considered and were released under life sentence, those serving a life sentence were considered and were released on occasions of national importance. So we would have a provision, we would have a situation where to commemorate or celebrate Independence Day, for example, the executive would release a number of persons. And from the decision of the Court of Appeal and from the comments and observations of Madam Justice Suhon in the Sipasad and Pancho sentencing ruling, it is clear that the practice appears to have been discontinued. Now, the logical conclusion to be drawn from the discontinuation of the practice is that the executive has now chosen to take the life sentence, not to determine life sentences in the manner in which they had been determined previously. So it is no longer safe to say 15 years or 10 years or 12 years. It may not be longer, it may no longer be safe to say 20 years. And it is entirely possible that the position is that persons who are sentenced to life imprisonment, the norm will now become that you are to have no stated practice, no policy document of the executive in relation to the life imprisonment sentences. So it is clear that these were concerns which troubled their lordships in the Court of Appeal. And clearly, the Court of Appeal felt a general unease by virtue of these considerations. Chiefly that the sentence is controlled. There was clear unease on the part of the Court of Appeal on this basis that militated against the Court of Appeal endorsing an automatic and mandatory life sentence. Further, what clearly troubled the Chief Justice was the lack of consistency in approach. And therefore, the Court of Appeal refused to hold that a life sentence was the only appropriate sentence available to a court, and hence left the matter to be determined by the High Court at a sentencing hearing. Now,
Mr. Seeper
all
said,
of these
Mr. Seeper said we did lose you there for a few seconds.
Sorry, my lord.
We did lose you there for a few seconds.
Yes, my lord. I'll just repeat that.
Can you assist me on this? I mean, you're now approaching you in fact started early yesterday, and you're now approaching the limit of the time that's been allowed for your submissions, even if we make allowance for the interruptions this morning. I don't know how much longer you need.
My lord, I would like to wrap this up in probably 15, 20 minutes, my lord.
Yes, but I think you ought to bring your submissions to a conclusion now.
Yes, my lord. So, my lord, it is important to bear in mind that at a sentencing hearing as envisaged by the order of the Court of Appeal, all of these matters can be dealt with and gone into with evidence and so on and so forth by that sentencing court before determining what is an appropriate sentence. So the upshot of this is that a court, and this is the important part, the court sentencing an offender to life imprisonment must be taken to do so in the knowledge that the sentence will be determined by the executive, either by the act or omission, and not a court or other independent and impartial tribunal. The court cannot say when or whether an offender under such a sentence will be released or even considered to be released. And all of these propositions do arguably lead to the conclusion that a life imprisonment, sentence of life imprisonment in this jurisdiction should be reserved for the worst of the worst. Those who the court is intent should be removed from society for as long as possible. And in those circumstances, we bear in mind paragraph 44, where the Chief Justice indicates the court must be specific in articulating the punishment it intends to impose. Well, the very last point we wish to make is very brief. It relates to the composition of the Court of Appeal and its judgment. And respondent says that considerable weight should be afforded to the views of the Court of Appeal on this matter for two reasons. One, sentencing is preeminently a matter concerning local conditions, and as was stated in paragraph 80 of Lendor, should be dealt with by those immersed in those local conditions. And secondly, the composition of this Court of Appeal was particularly well placed to deal with these issues. We had the Chief Justice, who sat in both civil and criminal jurisdictions and is a former Crown Prosecutor and Solicitor General in other jurisdictions. Mr. Mohammed, Justice of Appeal Mohammed, was a former DPP who sat in both civil and criminal jurisdictions. And Madam Justice Suhon was a senior criminal practitioner and sat in the assizes for many years. And we commend those propositions to the board. So, my Lord, we rely on our written case in relation to issues number 3 and 4, as raised by the appellant. And we say, and I will just briefly refer the board to the Citation and Pancho decision, which is in our supplemental electronic bundle, and it's paragraph 41, because we say that those issues, one, do not arise for consideration before the board and ought not to engage the attention of the board. And two, those two issues are really an invitation for the board to give guidance on matters which are far too fact-specific, i.e. circumstances and so on, and that the board should decline that invitation, which was the board's position in the Citation and Pancho judgment at paragraph 41. So, my lords, with that, unless I can be of any further assistance to the board, those are the submissions for the respondent on the appeal.
Yes, please. Yes. Mr. Sipasad, could you help me, please, with one aspect of the practical operation of the sentence of life imprisonment? Once the offender is released, whenever that may be, in Trinidad and Tobago, is the sentence literally at an end? May he be recalled under any circumstances?
No, my lord, and that is why I mentioned that we have no license provision. So it is the determination of the sentence, right, and that is the end of the matter.
Thank you, but that's license conditions. If he were to reoffend, would he be required to continue serving the life sentence, or would he simply serve whatever sentence might be imposed for the new offence?
For whatever sentence might be imposed for the new offence.
Right. That's very helpful. Thank you very much.
Yes, ma'am.
Thank you. Thank you, Mr. Sipasad.
Thank you, my lord.
Mr. Middleton.
My lord, can I begin with an outline of the cross-appeal? We now have the transcript of what the Court of Appeal said when it made the decision to make no order as to costs. We did not have the transcript when we settled our written case, but the issues arising were anticipated in our case. As we shall see when we look at the transcript, the Court of Appeal gave two reasons for its decision to make no order as to costs. Firstly, that the appeal raised a matter of general public importance. And secondly, that Mr. Boodram might yet be given a sentence of life imprisonment when his case was remitted to the High Court for resentencing. My Lord, in outline, the cross-appeal rests on three propositions. Firstly, although costs are at the discretion of the court, the general rule in Trinidad and Tobago is that the unsuccessful party should pay the successful party's costs. Secondly, we submit that Mr. Boodram was undoubtedly the successful party in the appeal. In short, he got what he wanted. Thirdly, on no analysis did the reasons given by the Court of Appeal for making no order as to costs justify a departure from the general rule. My Lord, we respectfully submit that the Court of Appeal's position on costs was illogical, wrong in principle, and out with the range of any reasonable exercise of the court's discretion on costs. And therefore, subject to the issues raised in the letter provided on Monday, which I'll return to later, subject to those issues, which I'll come to later, that the cross-appeal should be allowed. My Lord, the factual backdrop to these proceedings is an important part of our cross-appeal and important for an understanding of our challenge to the costs order, and we say important to understand the gravity of the Court of Appeal's error. So I propose to begin briefly by rehearsing the key parts of that background which have not yet been referred to the board, and to do so beginning at page 320. My Lord, page 320 is the judgment of Mr. Justice Raj Kumar, as he then was, in the Dottin proceedings. And as the board will appreciate, those were the proceedings that ran, as it were, in tandem with Mr. Boodram's proceedings and were then overtaken when Mr. Boodram's appeal was taken first in the Court of Appeal.
Mr. Middleton, can you just help me? You say we now have the transcript of the ruling on costs.
Yes.
In this matter. Can you just give me the page?
The page reference is 1526. I'll bring the board to that in a moment.
Very much.
1526. So we have at page 320 the judgment of Justice Raj Kumar. And of course, his ultimate decision was the decision that was appealed against to the Court of Appeal, and again was overtaken by Mr. Boodram's appeal on the same issues. But as we submit, rightly indicates in the first paragraph of his judgment, the proceedings had their genesis on Monday, the 6th of June 2005, and the days, as the board will see in a moment, are important. Monday, the Attorney General made a statement to Parliament that every person on death row will be hanged if the opportunity is available to the state. And as we'll see in a moment, there were several dozen, 50-odd prisoners, at least in that category. If the courts intervene, the state will, cognizant with the rule of law, do everything within its power to pursue the sentence of death in relation to every person on death row. Mr. Speaker, the state intends to insist that the courts, going through to the Privy Council, revisit the decision in Pratt and Morgan. We do not agree with it, although for the time being it binds us. We do not agree either with the statement of the Privy Council in Matthews, by which the Privy Council attempted, in our view, in defiance of the Constitution, to commute the sentences of persons on death row whose appeals were not even before them. We shall resist these decisions with every resource of the state. I say no more on this matter at the time. But what then happened is 4 days later, on the Friday afternoon, letters were sent to several prisoners on death row saying that their cases were to be considered by the Mercy Committee, the advisory committee, the following Monday.
Well, I think the members of the board are all aware of this background,
Well,
Middleton, and what's not clear to me at the moment is how this assists us in relation to the cost.
well, because when we come to the test as to whether the board should interfere with the Court of Appeal's decision on costs, it has to be plain that the Court of Appeal was in error, and we say that the gravity of the error is clear when we look at the facts. But if my lord is indicating that you have the facts, I don't need to dwell in any great detail on them. Save to say, if I can just highlight what Justice Raj Kumar said on page 324.
Yes.
Page 324, the truncated deadline unfortunately gave the impression that a real opportunity to be heard was not intended. And then in the next paragraph, this sequence of events and the timing thereof was quite capable of giving the extremely unfortunate impression that a statement in Parliament by one member of the Executive and the haste to convene a meeting of the Mercy Committee, which tenders advice to the Minister of National Security, another member of the Executive, were linked, and that the outcome was preordained. And it was worse than that, in that the Attorney General was also a member of the Mercy Committee. My Lord, can I then take the board to the chronology at page 411, and that then completes the factual background?
Yes, 411.
411, please. At page 411, you'll see that on that Monday, the 13th of June, the DOTIN applicants made their application, their constitutional challenge. At that stage, they were not, in fact, seeking a sentence other than life. And just for the board's note, you find that at page 137, but I won't take you to it. And that same day, Mr. Justice Benjamin makes a conservatory order to prevent any executions. It's Mr. Boodram who, when he files his application, it's Mr. Boodram who raises the issue of whether he should be entitled to a sentence other than death. My Lord, can I ask the board, please, to look at what he sought in his constitutional claim? That's at page 6. Page 6 sets out the two substantive items of relief. First of all, an order that his sentence of death be vacated. And secondly, an order that he be brought before a sitting of the High Court for resentencing on a date to be fixed, at which hearing the High Court may impose any lawful penalty other than the sentence of death.
Yes.
And then, my Lord, if one turns over to page 31, we can see by the time Mr. Boodram is in the Court of Appeal, the point is very clear indeed. Page 31, paragraph 3. On this appeal, when stripped to its basics, the appellant is seeking one principal matter of relief. I pause there to say that by that point, his death sentence had been commuted on an interim basis by Mr. Justice Barrow. The appellant seeks an order by which he will be allowed to convince or attempt to convince a sentencing authority to impose a term of imprisonment other than imprisonment for life. What had happened in the meantime is that Mr. Justice Raj Kumar had made an order saying that those persons who were party to the DOTIN proceedings had their sentences commuted, and those persons who were not, and that included Mr. Boodram, were entitled to have their sentences commuted. But he dismissed that claim, and Mr. Boodram's claim, which had been held to await and abide the DOTIN proceedings, was also dismissed. Mr. Boodram's appeal, as I've indicated, went to the Court of Appeal first, and the dot-in proceedings were to await and abide by the decision of the Court of Appeal. And so can I now take the board, please, to the transcript, starting at page 1527. This, my lord, is the transcript of the hearing on the 8th of March 2018, which is when the Court of Appeal handed down the judgment and the order that you've already seen, remitting the matter to the High Court and making no order as to costs. And in the initial part of page 1527, the Chief Justice is recognising that the dot-in matters are awaiting this matter. And then picking up at line 40 of page 1527, we get the Court of Appeals, the Chief Justice's summary of what had in fact been decided. And you'll see there that he's saying we have the view that upon a review of the authorities in the commutation resentencing exercise involved under Section 14, the full spectrum and discretion of sentencing powers is available to the court, and so on. So it's very clear from there, we submit, that Mr. Boodram had got exactly what he had sought in the Court of Appeal proceedings. Over the page, 1528, line 8, the Chief Justice says we are not seized with sufficient information to do the resentencing exercise, and so in the circumstances with the guidance provided in the written judgment, we are remitting the matter to the first instance court for consideration. He then goes on to the issue of costs. My lord, I'm now at line 14. With regard to costs, I don't think there would be no order as costs. Well, he either misspoke or the transcript is wrong, but it's clear from the context that he's saying there should be no order as to costs. He goes on to say, I think it is the appropriate, this is a matter I would think of general public importance, which is that acceptable to both sides? And counsel for the Attorney General says, yes, please, my lord. But Mr. Seepersad takes issue with that. He says the appeal that was argued has been successful. And my lord, I'm not going to read out the passage below. If the board sees that, what is being referred to there is Mr. Justice Raj Kumar's decision at first instance. And Mr. Seepersad is making the point that Mr. Boodram was not in fact covered by the order as to those sentences that were commuted. And then going over the page, you'll see at line 20 of page 1529, at this point the Chief Justice is referring to Mr. Justice Raj Kumar's order, which we all notice at page 396. He's saying that the prisoners, including Mr. Boodram, are entitled to have their sentences commuted, and Mr. Seepersad refers to the appendix, which sets out those details. And that then culminates in the Chief Justice asking at line 46 about how Mr. Boodram's case had come up, and Mr. Seepersad explained that. There's nothing controversial there. Going over the page...
Mr. Boodram's name was in the list of people who didn't want to take any part in it.
He was, my lord, yes. Yes, he was. That had been determined at an earlier stage, because at an earlier stage in the dotting proceedings, only life, the only sentence indicated had been life, but that changed in the course of the proceedings, as you'll appreciate from the Raj Kumar judgment. By then, it was clear that the dotting applicants were also arguing that there should be a discretion as to whether life should be imposed. But in the meantime, Mr. Boodram had detached himself from that, but he'd also agreed that the decision in his case should await and abide by Justice Raj Kumar's decision in the dotting proceedings. And then Mr. Seepersad's submissions culminate in his proposition at line 15 on page 1530, we have been successful on our appeal. There's then a change of tack, I submit, because the Chief Justice says we still don't know if he's going to get the relief that he ultimately seeks. And Madam Justice Suhan, we can't say because he has to be resentenced. Now, Mr. Seepersad, he is being resentenced by virtue of having won this, having gained this order from this Court of Appeal. That's what I'm saying, my lord. But the court continues, with Madam Justice Suhan. The learned Chief Justice said, this is a matter of public importance. Chief Justice, it was more in the nature of an interpretation. And you can see that reference there, an interpretation of what is meant by life imprisonment for guidance. And at that point, Mr. Sipasad says he will be guided. So that's why we say the two reasons advanced by the Court of Appeal were, first of all, it was a matter of general public importance, and secondly, he might yet be resentenced. My Lord, dealing briefly with the legal framework, my Lord, I can take that quite briefly because we've set it out in the written case. Our starting point there was Lord Carswell's dictum in the case of Sipasad and Persad. And if the board would like to look at that, that's at page 1505. Um, 1505, tab 36, my learned friends. That was a personal injury claim, so the details were of no relevance to this matter, but the dictum we rely on is at page 1514, where Lord Carswell makes the observation about 7 lines down, paragraph 24. The award of costs in Trinidad and Tobago is in the discretion of the court, as usual in most common law jurisdictions. The general rule, which should be observed unless there's sufficient reason to the contrary, is that costs will follow the event, and then there are observations about the circumstances in which the general rule might not be applied. My Lord, that case was decided on the old rules of the Supreme Court, but we know from the dictum of Justice of Appeal Bureau in the case of Aline that they still apply today under the civil proceedings rules. And my Lord, we've given the reference in the case. I'll give it to you now. It's page 1536, but I don't propose to take the board to it now. It does not appear to be contentious. But can I take you, please, to the civil proceedings rules, and in particular part 36. My Lord, these are in the supplemental bundle of authorities, which was filed last week. In the supplemental bundle, page 7, the board has part 66, and in particular part 66.6 of the civil proceedings rules of Trinidad and Tobago, and the general rule set out there in paragraph 1. If the court, including the Court of Appeal, decides to make an order about the costs of any proceedings, a general rule is it must order the unsuccessful party to pay the costs of the successful party. There are then other provisions that will be familiar to the board from our own rule approach to the costs, including at 4, at the top of the next page, in deciding who should be liable to pay the costs, the court must have regard to all the circumstances. And then at 5, some of the matters that might be taken into account when deciding not to apply the general rule. And one can see there, again, very familiar considerations about the conduct of the parties and whether a party has succeeded on particular issues and so on. We only say on that that none of those matters applied in this case, and none of them purported to be applied.
What's the general practice then, insofar as there must be a number of these cases, presumably in which prisoners will be claiming constitutional relief? And so what's the usual practice? Does they bring proceedings in the High Court? Do they get the costs of those proceedings in the High Court?
My Lord, I would have to defer to Mr. Sipasad on the actual practice of that, but can we come back to you on that?
And what's the form of that litigation? Does the state protect itself insofar as it concedes that there should be commutation of the sentence, and or does it hold out and have the matter argued?
Again, my Lord, as to the actual practice, I would have to come back to you on that. We can do that after the short adjournment. My Lord, there are particular considerations that apply as a matter of law in public law cases, and we referred here to Lord Staines's dictum in the case of Arnie. This appears in the bundle at page 1290. It's tab 32 for my learned friends. My lord, in Arnie, the issue was whether the appellant, who had had an order of contempt made against him, was right in arguing that the Supreme Court of Mauritius had the power to punish for contempt. It's page 1290. Again, the details of that matter are not relevant in this appeal, but what is relevant is the final observation by Lord Steyne at page 1303, letter G, where the appeal was dismissed, so the constitutional claimant was unsuccessful. But his lordship said, given that the real substance of the appeal concerned important matters of constitutional law, and that bona fide resort to rights under the Constitution ought not to be discouraged, their lordships may make no order as to costs. My lord, although that principle has not been formally reflected in the Trinidad and Tobago civil proceedings rules, this is not an alien principle in the Caribbean region, and for that we refer the board, if we may, back to the supplemental bundle at page 4. Page 4 of the supplemental bundle is the Eastern Caribbean Supreme Court civil procedure rules. And at page 6, we find the provision in part 56.13.6. The general rule is that no order for costs may be made against an applicant for an administrative order, and those, as the board may well appreciate, include judicial review, constitutional claims, and applications for declaratory relief, unless the court considers that the applicant has acted unreasonably in making the application or in the conduct of the application. And finally, my lord, on the legal framework, we refer to, in the same bundle, the dictum of Lord Justice Nui in the case of Essan. That is at page 26 of the supplemental bundle. Again, the particular facts in that case are not important, but we rely on what Lord Justice Nui said at paragraph 19. 19 is at page 32 of the supplemental bundle. The Court of Appeal is, of course, slow to entertain appeals relating merely to costs. While it will do so in an appropriate case, it recognises that the judge had a discretion, and where no error of law is shown, the appeal court should interfere only where the judge's exercise of discretion has exceeded the generous ambit within which reasonable disagreement is possible. So in this case, we respectfully submit that the Court of Appeal did exceed the generous ambit within which reasonable disagreement is possible. Can I then make those submissions in a little more detail? First of all, my lord, we submit that Mr. Boodram was the successful party in the appeal. That's why I took the board to what he claimed in his claim for constitutional relief and what he actually got. Secondly, applying Lord Carswell's dictum, he should have been awarded his costs in the appeal and in the High Court unless there was sufficient reason not to do so. Thirdly, none of the reasons in the civil proceedings rules for reducing his costs or not awarding him his costs were present in the appeal or relied on by the Court of Appeal. So we submit there were no sufficient reasons to be gleaned from those exceptions to the general rule, to depart from the general rule set out in part 66.6. Fourthly, the Court of Appeal's suggestion that Mr. Boodram might ultimately be sentenced to life was not a logical reason, we submit, to depart from the general rule. As we have seen, he pursued the appeal to establish the principle that the resentencing court would not be limited to imposing life imprisonment. The Court of Appeal accepted that argument So the fact he might be sentenced to life on remittal was irrelevant to the issue of costs in the Court of Appeal. At most, it would arise as an issue in the High Court, that stage not yet having been reached. Finally, the public importance of this case was only relevant, we submit, as a reason not to award costs against Mr. Boodram if he had lost. On no analysis was that a reason to refuse him his costs having won the appeal. And my Lord, we do submit, having regard to the factual background and the nature of the proceedings, that this is an extremely important point. If the Court of Appeal's approach were to stand, it would have a chilling effect on public law challenges to unlawful actions by the state. By discouraging bona fide resort to rights under the Constitution, Lord Staines's words in Arnie. We submit it would be anathema to the rule of law because it would mean that public law challenges would become the preserve of the rich and the powerful unless litigants could find lawyers prepared to work at low cost or no cost. It would therefore be fundamentally wrong in principle. This was not only a matter of exceptional public and constitutional importance, it was also one that clearly needed to be brought. Can I conclude, my Lord, with two final observations? The first is to deal with the cases relied on in the Attorney General's case. My Lord, we've addressed those points in our written submissions. Unless the Board would like me to, I don't propose to rehearse them again. We simply say the cases relied on by the Attorney General do not support the proposition made. Yes. That only leaves, my Lord, the letter sent on Monday. To a significant extent, my Lord, the Board will recall from yesterday's hearing the letter that was sent, and I'll be corrected if I'm wrong, but the broad proposition, as I understand it, is that the Attorney General's position is that the outcome of the cross-appeal will depend, or at least could depend, on the outcome of the appeal. It's set out in the letter. Can I indicate to the Board what our position on that is? And as I say, to a large extent, we agree with what the Attorney General is submitting. We agree in particular that the Board will need to decide the appeal first. There will then be two scenarios. If the Board dismisses the appeal, it will need, in our submission, to consider the merits of the cross-appeal. And if the Board then allows the cross-appeal, this, of course, will be a binding ruling of the Board, and it will affect, necessarily, future decisions by the courts in Trinidad and Tobago. My Lord, it's not necessarily a matter that needs to be canvassed at the moment, but it was raised yesterday. So in that scenario, our position when it came to submissions on costs would be that the Board ought to award costs in Mr. Boodram's favour at all stages. We are not convinced that anything particular needs to be said about him being represented pro bono. My Lord, the position is a little more complicated if the Board allows the Attorney General's appeal. If the Board allows the Attorney General's appeal, our position would be that the appropriate order in the Court of Appeal would have been no order as to costs, applying the Arnie principle that I've referred the Board to. In other words, even though Mr. Boodram should have lost his appeal in this hypothetical scenario, we would argue that the appropriate order would have been no order as to costs because it was a bona fide constitutional challenge. It follows, however, that we would have to accept that, albeit for the wrong reasons, the Court of Appeal made the right decision by making no order as to costs. And in that scenario, the cross-appeal would fall to be rejected. What we add to that, however, is this, my Lord, if we were in that scenario, we would respectfully invite the board nonetheless to consider the merits of our complaints about the Court of Appeal's decision on costs. And if it agrees with our complaint, to say so per curiam, not as part of any binding element of the board's decision, but as observations per curiam that would inform the practice of the courts below in the future and provide important guidance on what we submit is a very important issue.
But in those circumstances, you don't invite us to disturb the order of the court?
No, my Lord. In our submission, it would follow logically, as I think my learned friends are, that was a point being made in their letter. It would logically follow that we'd have to accept, albeit for the wrong reasons, the Court of Appeal had made the right decision in that scenario. My Lord, unless I can assist the board further, and as to my Lord Stephen's points, if I might just come back briefly after the short adjournment.
Yes, I don't think there's anything. Thank you, Mr. Middleton.
Could I just sort of check one thing? On the first scenario, if the appeal is dismissed, you say no need to mention whether the representation is pro bono. Presumably that's because the indemnity principle applies in Trinidad and Tobago as it would apply here. Is that right? So one just makes it an order for costs, and
one just makes an order
for costs. Costs are only recoverable insofar as
exactly. The Attorney General's bill would be much smaller in that situation because Mr. Boodram is being represented pro bono before your Lordship's board.
Yes, right.
But that was the point we were making, my Lord.
Thank you, Mr. Middleton. Mr. Pools.
My Lord, I'm grateful. Mr. Stevens is going to deal with the appellant's reply. I just propose to say some brief response to my learned friend's cross-appeal, which I may not finish in the next 2 minutes, I'm afraid. My Lords, the issue on the cross-appeal is whether the respondent should be awarded his costs of the proceedings below. As I submitted yesterday and in accordance with the letter that was written to the registrar, in the event that the appeal succeeds, it's accepted that he would not be entitled to his costs of the proceedings below. In the event the appeal is unsuccessful, the Attorney General accepts that the respondent should have his costs of the proceedings below. Accordingly, the issue that's raised on the cross-appeal is now academic in my submission. And in the circumstances, the board should decline the respondent's invitation to say anything in respect of the way in which the Court of Appeal dealt with the issue of costs, particularly where, as the board will know, the issue of costs is preeminently a matter for the local court, and particularly local Court of Appeal taking account of local practice and procedure. But without prejudice to that submission, I do say that the criticisms that are made in the respondent's written case as to the way in which the Court of Appeal dealt with the issue of costs do not withstand scrutiny when one now looks at the transcript. And I think it's important to appreciate, as my learned friend drew to the attention of the board, that when Mr. Sipasad made his witness statement, which I don't think is a document that yet has been referred to your lordships, it's at page 4, electronic bundle 467. And also when the respondents filed their printed case, they obviously didn't have the benefit of the transcript. And if one looks at page 467, which is the first page of Mr. Sipasad's witness statement, it's really only paragraph 2 that need to concern your lordships. It is said there in the second sentence, the court did not seek submissions from the parties on the issue of costs. And then goes on to effectively characterise what the Chief Justice said about costs as a bit of a throwaway line as he was leaving the court, and said no other justification was offered. Well, with great respect, Mr. Sipasad's recollection doesn't accord with the transcript which we now have, which makes it clear that submissions were heard. And in fact, Mr. Sipasad thanked the Chief Justice for hearing him and allowing him to make his submissions. And the Court of Appeal considered the issue and considered what the appropriate order should be made. The point is also made in the respondent's case, and this is EB 452, relying effectively on Mr. Seepersad's witness statement, is para 6.3. Again, making the point, no submissions were made on costs and no justification other than, well, you might still get a life sentence. It is quite clear when one looks at the transcript that there was more consideration given to the issue than that. My Lords, I haven't got an awful lot more to say on cost, but I appreciate I'm now straying into the short adjournment. So
how much longer? Have you...
Probably 5 minutes, my Lord.
We'll hear you.
I'm grateful.
Thank you.
So, as I say, without prejudice to our point that this is academic and the court, your Lordship's board should not should decline the invitation to say anything. I say, when one looks at the transcript, and that's at EB 1527 through to 1530, it is clear that the Court of Appeal gave proper consideration to the issue, gave the respondent an opportunity to be heard on the question of the appropriate order, and gave reasons for exercising their discretion in the way that they did. And just highlighting some passages that my learned friend didn't take you to at the end of the transcript. So you were taken to 1528, where at lines 14 to 18, it is said by the Chief Justice, actually this is a matter of general public importance. That is then picked up again by Mrs. Justice So Hun at 1530, line 26, where she says, the learned Chief Justice said, this is a matter of public importance. We do not think, and then the Chief Justice, it was more in nature of interpretation. And then Chief Justice comes.
Wouldn't a matter of general public importance be a reason for awarding costs to an applicant, as opposed to not awarding costs, so that these constitutional issues can in fact be decided by a court?
Well, my Lord, it's for the benefit of all parties, because what is the Court of Appeal is effectively giving guidance, and that was the passage. Just and as I answer my Lord's question, just to finish on the transcript, Lord Chief Justice says at 34, for guidance to the courts and parties involved, and so on. So in this case, I do not see how an order for cost could be appropriate. And then Mr. Seepersad says, well, I'm guided, and thanks for considering his representations.
I mean, if the Court of Appeal was going out of its way to give guidance and we think the guidance is wrong, shouldn't we in fact deal with the matter on the merits rather than just treating it as academic?
Well, my Lord, no, not where it is a matter of principle. So you may find that the Court of Appeal what they said was wrong, but the way that they were dealing with it, they were dealing with first a matter of general public importance, second a matter which they could give guidance to clarify what was, on the respondent's case, an irregular practice that had built up in Trinidad and Tobago about dealing with commutation and the sentence following commutation. And having considered the matter, the Court of Appeal decided that the appropriate order was both sides should bear their own costs. And I do make the submission that there's no error of law or principle that's identified by the respondent to justify interfering with what is ultimately an exercise by a local Court of Appeal of a discretion to award costs. And what is implicit in what the Court of Appeal is saying is, as I say, given the nature of the challenge, the constitutional importance, the large number of cases potentially affected, the general rule that the successful party should have its costs is displaced. And just, my learned friend referred to a potential chilling effect that the Court of Appeal's judgment might have on cases of public importance and constitutional claims such as this. It's quite clear when one looks at the transcript that the Court of Appeal is looking at the particular facts of this case. And if I can add to that, the unusual facts of this case. And what I mean by unusual is the way in which the respondent distanced himself from the dot-in applicants. And we see that when one looks at the transcript and the Chief Justice expressing some surprise as to how the matter has in fact come before the Court of Appeal in those circumstances. So it is quite clear that the Chief Justice and the Court of Appeal, they're not laying down a rule of general application. They're saying on the particular facts of this case, the appropriate order is no order for costs. So I say that the point made about chilling effect has no bearing here. Well, unless I can be of any further assistance, that's all I propose to say on costs.
Thank you very much. Middleton, anything further?
Well, my Lord, I hesitate to intrude further into the short adjournment. We submit it is in no sense academic, particularly if the board finds favour with our position on the appeal and rejects the appeal. Our position is that that the Court of Appeal went badly wrong in principle. And far from failing to identify any error of law, we submit we have identified very clear errors of law. It's clear from Lord Carswell's dictum that if you do depart from the general rule, a court has a discretion to do it, but you have to have sufficient reason to do it. And as my Lord Stevens points out, the fact that this is a matter of enormous constitutional importance and that it was provoked by the extraordinary conduct of the Attorney General, lambasting the apex court of Trinidad and Tobago in Parliament and making it clear that the state would do everything it could to kill everybody on death row. And that's what prompted the dotting proceedings.
We've got that point.
Yes. So just on the dotting connection that was taken by my learned friend, on the contrary, the way that Mr. Boodram conducted himself was to his credit. He said, it was agreed, and you'll find this in the Statement of Facts and Issues, he agreed that his proceedings would await and abide by the dotting proceedings. But he had introduced the very point that was central to Mr. Justice Raj Kumar's determination was a sentence other than life available. So there's no conceivable criticism at all of how he conducted these proceedings. So, my Lord, that is what we say in response to those submissions.
Thank you very much. Wise now, we'll sit again at 2 o'clock.